This is a presentation of the Lex Rex Institute, where we're committed to ensuring that the law remains our only king and that everyone is subject to it, even our leaders. I'm Alexander Haberbush, and I'm president of the Lex Rex Institute, and I'm also a practicing attorney in the area of constitutional law. Now, as always, just keep in mind that nothing in these videos should be understood as constituting legal advice. All right, let's take a look at this week's question. With everything in the news about the Roe v. Wade precedent potentially being overturned, I was wondering how precedent actually works. Do judges have to follow precedent? And if not, why does it matter if it changes? That's a great question. It's also a huge question and not one that we can fully explore today, but we'll do our best to give sort of a brief introduction to the idea of precedent. Now, before we do that, a brief disclaimer. Usually when I do these Ask an Attorney videos, I go in cold. I have my staff prepare the slides for me ahead of time and I just click through them. This week we actually discussed a subject that we thought had to be addressed for our viewers. Now, that subject is, of course, what we just looked at is going to be precedent. But before we do that, I want to make it very, very clear that the Lex Rex Institute has a firm policy that we will not under any circumstances engage in legal analysis or speculation or really any kind of opinion whatsoever about the leaked brief itself. For those who don't know, I'm sure that most people know at this point, it's been huge news, but for those who don't know, Justice Alito's draft opinion was leaked on Monday. First time in the court that a full draft opinion has been leaked. Obviously, it's not a final opinion, but still, it's a huge political issue right now. And because it's a huge political issue, it necessarily contributes to the further politicization of the court, which is something that we cannot have if we want to maintain justice and the rule of law in our society. You know, people can talk about how political the court is. That's fine. Our republic doesn't work unless the court is an apolitical branch of government. And really, sort of the great irony here is that a lot of the people who have complained most loudly that the court's become a political body are those who are now engaging in speculation and commentary about this leaked opinion, really doing everything in their power to further politicize it. Our Constitution calls for one Supreme Court. It does not call for a court of public opinion, and LRI will take no part in aiding a court of public opinion in judging this opinion that Alito has drafted. So, that out of the way, we did feel that it was necessary or very important for our viewers to understand how precedent works, because you're not going to understand what overturning precedent means or whether it's appropriate to overturn precedent or any of those issues unless you really understand the issues behind them. So we're going to be taking this video to explain what precedent is, why precedent matters. Then we'll have a follow-up video. Not sure if that's going to be posted this week, if I'll just record it right after this one, or if I'll do that one next week. But the follow-up is going to be when it's appropriate to overrule past precedent. So again, can't get fully in depth on these things, but we will try to give sort of an introduction to these subjects. Now, the other thing to keep in mind, precedent is probably the most misunderstood area in all of law. If I had a dime for every time somebody told me something about precedent that just is not true or misunderstood the way that it works in application, I'd be a much wealthier man than I am now. Let me say that. But before we get into that, that's why we can't cover everything today, but I am going to correct some of those misconceptions. So let's take a look back at the question. Do judges have to follow precedent? If not, why does it matter if it changes? Well, like anything else, no, they don't have to do it. It's no different from a garbage man. He doesn't have to collect the trash, and a surgeon doesn't have to stitch his patients back up. If a judge doesn't rely on precedent, however, he's a very bad judge, because that's an extremely important part of his job. And not just a bad judge, but because laws are so integral to the functioning of our society, there's a substantial risk that you could face political or structural collapse if judges do not uphold precedent. So that's a pretty big claim. I'm going to try to justify that by the end of this video. But before we do that, obviously the idea of precedents faced a lot of criticism. A lot of people think it's silly that judges have to uphold past rulings, whether or not they were good rulings. So let's look at some of the comments that have been made over the years criticizing this idea of judicial precedent. All right, this one's from Jeremy Bentham. He's a very famous philosopher, famous for utilitarianism. Sorry, stuff just falling right there. famous for utilitarianism, was also very critical of the Anglo-American common law system. He actually wrote a response to Blackstone's commentaries on the laws of England, basically saying why the laws were bad. And he had this to say about precedent. Adjudication is the act of being methodically ignorant of what everybody knows. That rings kind of true, doesn't it? You know, we see a lot, every day in the news seems like some kind of boneheaded judicial opinions coming out and you're saying, how the heck did a judge reach that conclusion? I remember I live in California and a few years ago, a judge decided we couldn't use any water in the California Delta because there was an endangered smelt living in the Delta. And even though they said they could get this water without killing the smelt, said he couldn't do it. And we've had a drought ever since then. But you know, there's lots of examples of that, particularly in things relating to the internet or computers. Judges tend not to be that great at that. Judges tend to be older. But you can see why Jeremy Bentham would say this. Another comment is from Jonathan Swift, probably the most famous satirist of all time. He wrote Gulliver's Travels. He also wrote A Modest Proposal. And he said, "It is a maxim among these lawyers that whatever hath been done before may legally be done again. And therefore they take special care to record all the decisions formerly made against the common justice and the general reason of mankind." You can sort of see the reasoning here. If it's really a very sensible decision, why bother recording it? Another sensible person going to reach the same conclusion, so they just end up recording decisions that are against common justice, general reason of mankind. And then the last comment's actually from a former Supreme Court justice. He said this just before taking the bench. It's from Oliver Wendell Holmes, probably one of the few Supreme Court justices whose names you have heard before, who's become a household name. And what he had to say is, "It is revolting to have no better reason for a rule of law than that it was so laid down in the time of Henry IV. It is still more revolting if the grounds upon which it was laid down have vanished long since, and the rule simply persists from blind imitation of the past." That's a pretty harsh thing to say. Obviously, you can see that he's sort of criticizing what people could call a mere preference for history, saying that the fact that it's been done in the past is not sufficient reason to keep doing it. So those are people who don't like the idea of precedent. Sort of the irony of citing these things is that even by citing these people, I'm actually invoking the idea of precedent, because I'm looking at people who had authoritative things to say, are considered significant figures, and then relying on their opinions. But that's neither here nor there. But why should precedent matter? We believe that it should. We believe precedent should influence the way that judges rule on future cases. In other words, past cases should influence judges' decisions on the current matters before them. But why is that? Well, to answer that, let's first look at what precedent is. And to do that, we've got to look at what the law is. So when it comes to the civil law, in Anglo-American jurisprudence, you've got two different kinds of law. You have the lex scriptura and the lex non scriptura. Those are Latin words, and all they mean is the written law and the unwritten law. So what's written law? Well, written law is going to be things like constitutions and statutes, statutory codes, like United States Code, Penal Code, things like that. Unwritten law is going to be cases and decisions written into the common law. Now, I know what you're thinking. Cases are written. Yeah, that's true. Nowadays, cases are written, but you analyze them very differently from something that was principally and originally written down. So for hundreds of years, cases were not written down. They were merely an oral tradition. The fact that we now keep records of them does not keep them from being an oral tradition. So they're examined a little bit differently. When it comes to written law, statutes and constitutions, we're going to be very focused on the words used, the grammar used, very technical. Statutory interpretation is real boring, and probably, not the most flashy or glamorous part of the law, but that's what you do when you are analyzing written law. Well, what are these cases and decisions? What is this unwritten law? Well, those interpret the written law in our context, as well as some of them are rules that are rooted in the common law way, way back. In fact, a lot of it is like that. We've talked about common law before. We could probably do a video on that subject on its own. But those unwritten, for our purposes, what you need to know is that unwritten law, those cases, what they do is they comment and interpret and specify and apply rules, whether it's rules from written law or just rules that have existed since ancient times and we don't really know where they come from. And these rulings, these decisions in courts, they apply and bind subsequent courts. This is a principle called Starry Decisis. That's Latin, and it's actually part of a longer phrase, which is Starry Decisis et non quieta movere, which means to stand by things decided and not disturb settled points. In other words, the issue has already been settled in the past. There's no reason for a future court to re-examine it because we already know the answer to that question. Another person to look at for this is going to be William Blackstone in his commentaries on the laws of England. Remember, William Blackstone is going to be sort of the founding father's foremost authority when it comes to legal matters. He was writing in the 1750s and sort of systematized the English law up to that point, which becomes adopted in America as the American legal tradition. And what he had to say is that it is an established rule to abide by former precedents where the same points come again in litigation. So that's what he had to say about precedent. That's what precedent is. It's the established rule that when the same points come up again, that judges will rule the same way on those points. Now, what does that mean? Well, a really good way to think about this, I don't want to get into anything too technical here, but you can really apply this with any sort of rule. Think about rules that parents give their kids. So say two kids are in the backseat of the car, and a brother and a sister, and they keep messing with each other. Well, the parent can say, nobody can reach over the middle of the car, the middle seat on the car. Well, that's a wide space, right? So then say that the younger brother reaches halfway over the middle and just starts touching his sister's arm again. Does that violate the rule? Well, we have that whole space as far as the armrest is concerned. Does reaching over the armrest mean reaching all the way over the armrest so that you're on the other side of it, or does it mean reaching past the direct center of the armrest? A lot of different ways you could go with that, and I'm sure that anybody who's a parent, with more than one kid at least, has dealt with their kids trying to get around rules in this way. But what precedent means is that once the parents have said, say for instance, means you cannot go past the center point on that armrest of the car. Well, once they've decided that, that's the rule that's going to apply in all subsequent cases. So whenever the brother and sister are fighting in the back seat again, one of them reaches over the center of the armrest, that rule's already been decided, doesn't need to be argued about again. That's what applies going forward. So if precedent applies in cases, then the task of judges in looking at new cases that have issues that are similar to old ones is then to either follow the past precedent or to distinguish the present case from the past precedent. So say that younger brother hands the sister, you go through the drive-through. The mom hands the younger brother drinks for everybody. Younger brother hands the drink to his sister. Sister grabs it. And then she's a real legalist, so she catches, hey, he reached over the armrest to do that. Well, now the mom's got one of two choices. She can either say, that past rule that I gave continues to apply here. You reached over the armrest, you're in trouble, younger brother. Or she can say, this is distinguishable from the issue that we've talked about before. Previously, those past cases had to do with messing with each other, and handing your sister a drink doesn't really fit into that, so I'm going to distinguish the present case from the past rule. It's pretty much all precedent's doing in these cases is any rule somebody makes, there's going to be ambiguities in it, there's going to be questions that are raised, and precedent establishes patterns going forward that will be followed in future cases. So a few mechanical things to understand about precedent. Precedent's not just anything a court said. If a judge says something to the bench, it isn't automatically going to be precedent. So when does something become precedent then? Well, first of all, precedent can only bind lower courts as to higher courts. So we talked last week in our Ask an Attorney video, and we'll link that in the description if you're interested, about the different levels of courts, different kinds of courts in the United States. But a district court is not going to be able to write a judicial precedent that will be binding upon the Supreme Court. Doesn't work that way, only works top down. And in addition to that, for precedent to apply, the judge must have rendered on an issue of law, not an issue of fact. We talked about the law-fact distinction previously as well. I don't remember which video that was either, but we can also link that one in the description below, and we will do that. Moreover, if it's a panel of more than one judge, the opinion must have been rendered by a majority of the voting judges. So dissenting opinions, concurring opinions, those are not law. And then lastly, precedent pretty much only pertains to the issue which was actually before the court and upon which the court decided. It doesn't apply to extraneous reasoning that may be in the opinion, doesn't apply to things that may be implied or assumed in the opinion. It only applies to the reasoning behind the ruling in the opinion. So those are things to keep in mind about precedent. Next thing to remember, and this is an important one, Precedent, or Starry Decisis as we referred to earlier, Starry Decisis is not really a doctrine, it is more of a technique. What do we mean by that? Well, we mean that a doctrine would be something like res ipsa loquitur, which is a doctrine in torts, that if you can't figure out what caused the harm to somebody, but logically it can only possibly be one thing, you don't have to have direct evidence of that cause, you can just say the thing speaks for itself. That's what res ipsa loquitur means, the thing speaks for itself. That's a legal doctrine. Starry decisis isn't like that, because Starry decisis does not tell a judge how to rule on a particular matter. It prescribes a method and set of procedures for any ruling that a judge may reach. So whatever a judge decides, they're expected to place it within a framework of cases and existing decisions. That's what I mean by a technique. Now, I'm going to jump now into a defense of the idea of Starry Decisis. And I'm going to give 4 main reasons why I think Starry Decisis makes a lot of sense and why judges really ought to defer to past opinion. And keep in mind, this is how our justice system works. Judges do defer to past opinion. Deference to past opinion is very, very strong. Starry decisis is a very strong principle in our law. Only under very rare and exceptional circumstances will precedent ever be overturned. You generally don't want to do that. And some of my reasons for precedent are going to get into why it's a bad idea to do that. But just know that we do face overruling past precedent with great trepidation. Okay, so let's look back at that Oliver Wendell Holmes quotation for a second. Remember, he said, "It is revolting to have no better reason for a rule of law than that it's old," basically, and especially if the reason for that law has long since vanished. And that's what we had to say about it. Well, what's my response to that? Well, I'm going to respond to that by saying, really, just the opposite. I'm going to say you're wrong. Past cases are worth consideration merely by virtue of the fact that they are our past. Now, I know what everyone's thinking. That's not a response. You just repeated the opposite thing from what Oliver Wendell Holmes said. And worse yet, is chronological bias, right? This is the chronological fallacy that merely because something's always been a certain way means that it should keep being that way. Well, if that's what I'm doing, then you would rightly chastise me, but I don't think that's what I'm doing. Let me explain why. It is very, very difficult to imagine what justice looks like purely in the abstract. We've done videos where we talked about this before, but people have come to vastly different conclusions about what justice looks like. And if a judge, whenever a case comes before them, is deciding huge matters of justice anew every single time, that's just not a workable system. Answering smaller questions is far, far easier than answering huge questions. It's much easier to answer, did that person actually touch that other person, than it is to answer, should somebody be compensated for somebody else touching them? It's a smaller question. Looking at smaller questions is always going to be simpler, more predictable, so on and so forth. Moreover, our system is actually a lot like the scientific method in that it deals with questions of law by increment, by degree, and on specific sets of facts. And because it's able to do this, because it deals with things by increment, it's actually able to be fine-tuned. We have passed rules, but we've had so many different cases that have been brought on those rules that by the time those cases have been honed and refined, we're able to get something that works really well in almost all circumstances. Think about, to compare to the realm of science again, think about if anybody's been following the whole Theranos thing with Elizabeth Holmes, who basically defrauded tons of investors in her machine that was basically she claimed it was going to do however many, like 100 some blood tests with only a drop of blood. And she got tons of huge investors. I think Rupert Murdoch invested tens of millions of dollars. I don't remember how much, but she started this whole company and a lot of people invested in it, but the whole time, the scientific community, people who actually knew about blood tests, kept saying, this can't work. This is too big of a leap. Right now we take many vials of blood for the kinds of tests that she's talking about. You could have an improvement, but the improvement would be maybe one fewer vial or maybe slightly smaller vials. You're not going to have a quantum leap of improvement from one company. It just doesn't happen that way. Well, precedent works exactly the same way, and that's why the historicity of precedent matters. Because if a lawyer looks at a current case and then tries to consider what a judge is going to decide on that, we know that it's going to be within a relatively narrow window of what it's plausible for a judge to decide, because our system only advances or changes or modifies by very small increments. To look at William Blackstone again, let me go ahead and pull that up. So William Blackstone articulates exactly this point when he says that whenever a standing rule of law, of which the reason perhaps could not be remembered or discerned, hath been wantonly broken in upon by statutes or new resolutions, the wisdom of the rule hath in the end appeared from the inconveniences that followed the innovation. So what's he saying there? It's a kind of old-fashioned language. What he's saying there is that, lots of times in our history, judges have decided that the old common law rule didn't make much sense in their case, and they changed it. And it may have seemed like a real great idea at the time, but lo and behold, a little bit later, it turns out that it just does not work in the majority of situations. Why is this? It's because if you're writing a law down, it's actually impossible to anticipate every possible application of that law. You just can't do it. I mean, using a simple example again, I think families, parents are always a really good example of rules because they make a lot of them and a lot of them get broken. So say that a parent has a son, say you're the parent, and say that you have a son and you've given your son the rule that he cannot go out with his friends until his chores are done. And also, let's say one of his chores is to walk the dog every day. Makes sense, okay, can't go out until his chores are done, has to walk the dog every day. Well, let's say that he's given a group assignment by school and it's due tomorrow. The teacher only gave him a couple days to do it, and it's not that he procrastinated, but it's due tomorrow. And currently the dog is at the groomer. It's getting a trim, I guess. Well, you didn't think of that situation when you made the rule. Does it apply here? It may not, but certainly you didn't think of this situation. And it's actually, you can actually go one further and you can say, is meeting for a group assignment, is that actually going out with friends, or should we distinguish that from going out with friends? Moreover, maybe he took the dog to the groomer. Maybe that counts as walking the dog. I don't know, that seems a little bit more of a stretch, but a lot of issues here. The point is, you didn't anticipate every possible situation here. It's impossible to anticipate every situation. So it makes sense that when new situations arise, you would create rules that would then become fixed and apply against future judges, actually limiting the ability of that judge to exercise his own opinions and his own arbitrary use of power, which leads to my second point. And that is that the principle of stare decisis is an important limitation on the judicial power. Now, keep in mind, our constitutional system is one in which all power is going to be bound by another power. If you look at the Constitution, that's probably least true, at least from the text of the Constitution, in the judiciary, in the Article 3 branch, the courts. Why is that? Well, as we talked previously in a different video, that's because a basic presumption of our Constitution was that the courts were already bound by past rulings. Let's take a look at what Alexander Hamilton had to say about this in Federalist number 79. What he says is, to avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents, which serve to define and point out their duty in every particular case that comes before them. So this is, again, iterating the same point. This is the only way that we limit the power of judges, is by, well, not the only way, but it's an important way that we limit the power of judges. And significantly, keep in mind, about half of the delegates to the Continental Congress that ended up declaring independence from Great Britain were lawyers. Declaration of Independence, as we mentioned before, is sort of a covenantal lawsuit against the King of Great Britain. It was fully expected and an integral part of our system, as originally envisioned, that we the people, specifically through the legal process, lawyers defending cases, that we would enforce the dictates of the Constitution and hold judges accountable by citing the law. And again, most of what the law is going to be judicial precedent. All right, so third reason, and this one so the last two reasons I'm going to say right now. Last reason is going to be that I think that following precedent is far, far more just. I think it's a much more just system than one that does not abide by precedent. But number three, I want to get first, and that's basically, even if it's not more just, I want to suggest that even if we don't care about what kind of system is just, it's actually a lot less important to have a right answer to a question than it is to have a clear answer to a question. Probably the classic example of this is which side of the road to drive on. It's not morally wrong to drive on the left-hand side of the road the way they do in Great Britain. It's not morally right to drive on the right-hand side of the road, but you sure doggone hope that people living in the same civil society drive on the same side of the road. To take this to the realm of case law, let's look at an old case. It's Pearson v. Post. It's an 1804 case, one of the cases that every first-year law student reads in a property law class. What this case looked at was a man by the name of Post who was hunting foxes, He'd been chasing out a fox all day, I guess, had rooted it out of the woods and been chasing it down. I guess it's a long process to hunt foxes. I don't know. I've never done it. But been hunting it all day. And Pearson, who I guess had some kind of history with Post, they didn't like each other too much, but Pearson had been watching Post do this. And he kind of waited back, and then at the very last minute, he sprung him, chased down the fox, and then shot it before Post had gotten to it. And Post then sues Pearson for trespass, saying that the fox actually belongs to Post because right of the hunt is to the person that chased down the fox. Well, the court examined this issue, and they cite about 20 ancient philosophers in answering this question. Kind of a silly question, but it had serious issues in it. And they end up concluding that the ownership of a wild animal doesn't start until that animal's mortally wounded, trapped, or captured. So they do end up siding in favor of Pearson. Is that just? Could the case have just as easily gone the other way? Maybe. I'll leave that to philosophers. I'm not going to voice an opinion on the way the case should have gone. But the point is that now that we have a ruling on this, hunters know exactly how it works. You're not going to feel cheated if somebody does this. You'll probably take precautions against somebody doing this, in fact. And it's something you can deal with if you know what the rule is. Again, in many, many instances, it's more important to have a clear rule than it is to have a correct one. Now, I want to also be clear on this, that we are not, Lex Rex Institute is not endorsing the idea of a utilitarian law or saying that law is merely that which is most conducive to positive social outcomes. We're just saying that even if you totally disregard the question of which laws are right and wrong, precedent still makes a lot of sense because, above all, laws have got to be clear. It's no good to have a morally right law that nobody understands or knows what it means. That does us no good at all. Which leads to the fourth reason why I think precedent makes sense, and that is the interests of justice. And there's several subparts in this one. So first one's going to be advance notice. Now, what is that? What is advance notice? That just means that we know what sorts of conduct run afoul of the law so that we can adjust or modify our behavior to meet the law's demands. In a society in which we have the rule of law, particularly in which we have a written law and in which we, the people, govern and are expected to make decisions about those who will be in charge over us, it is extremely important that we know our rights, and this is impossible without advance notice. Well, that's exactly what precedent does because you're able to look at past cases and see how future ones are going to be decided. But the biggest reason why precedent is extremely important to the interests of justice is that it promotes both the public perception and the actual fact of judicial neutrality. And that's really the reason why we made this video today. As we mentioned earlier, with this leaked opinion from the Supreme Court, severe questions have been raised about the court's neutrality. Well, I want to suggest to you that abiding by precedent is the only way that we can actually, in fact, get judicial neutrality and produce public perception of judicial neutrality. Again, to quote Alexander Hamilton in Federalist number 79, he says, referring to the judiciary, that it may truly be said to have neither force nor will, but merely judgment. When a judge issues an opinion, they are not voicing their own personal opinions. They are not trying to make something policy. Or at least they shouldn't be. They should merely be looking at past precedent and trying to rule in an intellectually honest way that is consistent with those past decisions. And you can have your doubts about the ability of judges to do this or whether or not judges in fact do this. People can debate about that all they want, and some of those claims might be valid. But as I've mentioned earlier, it is impossible for us to have a functioning society unless we can trust judges to do this, because at that point, we lose our political process entirely. We've got to have some kind of law that we can ultimately depend on, that we can use to anticipate what consequences are going to be, so that we can know our rights and defend those rights as citizens who exercise sovereignty under a constitutional republic. So this is the single biggest reason. Blackstone says this very, very eloquently as well. Let me turn back to that now. This is from William Blackstone. It's right after the section that we read earlier where he says that it's an established rule to abide by former precedents, and then he explains why. And he says, as also because the law in that case, being solemnly declared and determined, what before was uncertain, perhaps indifferent, is now become a permanent rule, which it is not in the breast of any subsequent judge to alter or vary from according to his private sentiments. he being sworn to determine, not according to his own private judgment, but according to the known laws and customs of the land, not delegated to pronounce a new law, but to maintain and expound the old one. So again, what William Blackstone is saying here is that judges are not supposed to be ruling on the basis of their own private sentiments, their own opinions, their own ideas of what's right and wrong, their own concept of what a good society is going to look like. They're supposed to be looking at the laws as they presently exist, and then faithfully in an intellectually honest way, applying that precedent to future decisions. That is the task of a judge. That is why precedent is so important. It is integral to the entire concept of the rule of law. You cannot have the rule of law without binding judicial precedent, because if you don't have it, it becomes merely the opinion of a judge. I know we call them judicial opinions, but what we mean by that is it's an opinion on what the law says. It's not just their personal opinion about what's a good idea. But without this concept of precedent, that's exactly what you're going to get, because there is no way that you can ever write statutes that are sufficiently detailed or entertain a sufficient number of circumstances that they will not be subject to interpretation. They're always subject to interpretation. So how do we deal with that? Well, we make people bound by the past interpretations of those who came before them. So that's what precedent is. Hopefully you enjoyed this video. I know it's sort of a big subject and there's a lot more to say on it. In fact, our next video is going to be about when precedent ought to be overruled. So go ahead and take a look at that one if you are interested. As always, we do appreciate contributions if you feel moved to make them. As we've mentioned before, most of our cases are funded by private individuals. We take most of our money from contributions, and we do take most of our cases either pro bono or at very, very low cost to the client. And the only way that we're able to do that is contributions from people like you. So if you do feel moved, go ahead and I think the link is in our description. It's lexrex.org/donate. If you like this video, click like. If you really liked it, click subscribe. Make sure to click on the bell icon for notifications. There, I'm finally getting that right each time. All right, this has been a presentation of the LexRex Institute. Thank you so much for watching.